first article that I will discuss is the Article 1183. This article affirms impossible conditions, those contrary to good customs or public policy, and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. This refers to suspensive conditions. Take note that this only applies to cases where the impossibility already existed at the time the obligation was constituted. What are the two kinds of impossible condition? We have first, physically impossible condition, because naturally it is impossible to happen or fulfill. Second, legally impossible condition, conditions that is naturally possible to happen or fulfill, but it is contrary to law, morals, good customs, public order, or public policy. So what are the examples of impossible conditions? These are the following. A. Promise B to give his car if the wind will not blow during the day. A. Oblige himself to give 100,000 pesos if he swims across the Pacific Ocean. Next, A. Promised B to give his car if the latter will kill C. A. Promised B to give his car if the latter will slap his mother in the face. All obligations and conditions are void. Why? Because impossible conditions annul the obligation which depends upon them. These examples are under conditional obligation void, one of the effects of impossible condition. The second sentence of the article is if the obligation is divisible, the part thereof not affected by the impossible condition shall be valid. For example, A. Oblige himself to give B his car if the latter will kill C, and to give 10,000 pesos to B if he will marry on or before the 30th of December 2020. The first obligation, which is to give the car, is void since it is dependent upon a legally impossible condition. However, the obligation to give 10,000 pesos is valid. The second paragraph is in effect of conditional obligation valid because the condition is always fulfilled when it is not to do an impossible thing. If the condition is impossible, it is disregarded and the obligation is rendered pure and valid. For example, A obliged to give B his car if B will not kill C. The condition is negative, which is not to kill C. Then it is regarded and the obligation is rendered valid. Moreover, the obligations are pure and demandable at once. But what if there is a pre-existing obligation? Now, the fulfillment of this will not be dependent on the impossible condition. Therefore, only the condition is void. For example, A borrowed 10,000 pesos from B, but A will only pay B if he will kill C. If B later agreed to kill C before A pays him, the condition to kill C is void, but not the pre-existing obligation of A to pay B, simply because he owes a money to B. Now, let's proceed to the positive and negative conditions, which is the next articles that I'm going to discuss. Article 1184 states the condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires if it has become indubitable that the event will not take place. While the Article 1185 states the condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. Article 1184 refers to a positive condition. Here, the obligation is extinguished as soon as the time expires without the event taking place, and if the circumstances renders the condition to be impossibly fulfilled, the event will not take place. For you to easily understand the given statement, I will give you an illustration. Zay obliged himself to give his car to Y if Y passes CPA board exam on October 2020. Now, if Y did not pass on October 2020, the obligation will be automatically extinguished. Or, if Y suffers mental incapacity to take the board exam on October 2020. But, if Y were able to pass the CPA board exam on October 2020, and thence the obligation will take rise. A question may be posed for the positive suspensive condition. What if the debtor will make the suspensive condition becomes impossible to happen? Will the obligation be extinguished? The answer is no, because the debtor is in fraud, therefore the obligation will be extinguished. Moving on to Article 1185. This refers to the negative condition. For example, say obliges Sol to give his car to Y if Y will not pass the CPA board exam on October 2020. Here, if Y did not file for the board exam on October 2020, or if he did not pass that specific exam and if he suffers from a mental incapacity, say will be automatically liable to Y to give his car because the obligation is effective when the time has elapsed. On the second part of the Article 1185 states, if no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. The obliging Sol to give his car to Y if Y will not pass the next CPA board exam. As you can see, there is no specific date or time fixed. Hence, the period will be dependent on the intention of the parties. Even so, the purpose of the obligation is dependent on the next board exam. Second instance is the last article that I am going to discuss, referring to Article 1186, wherein the condition shall be deemed fulfilled when the obliger voluntarily prevents its fulfillment. To illustrate this, here is an example. A promised B to give his car if the latter will do 5 push-ups, but A ordered C to break his hand while he is sleeping. So, the law says, if the debtor renders the impossibility of performance as if the suspensive condition already took place, then the obligation to perform or fulfill will arise. This also applies in resolutory condition. For example, A obliges Sol to give C his car if B will not see D until the 20th of April, but A fetched C and came together to see D. This explains that the obligation is still valid because A is the reason behind their encounter, so that he won't give his car. From this, you always have to remember that the debtor is doing this in intention to evade the obligation. Thank you.